All right, peace and blessings. It's February the 14th of 2018. You know, this whole issue of getting indictments by using fraudulent affidavits or just outright forging indictments, it's a pattern I'm seeing among several political prisoners. And when you start to see a pattern, you want to promote it and get the message out as much as you can. Somebody also sent me this article, and see, a lot of times when a political prisoner talks to me about their forged indictment or using faulty affidavits to get a fake indictment, they don't necessarily want me to mention their name because it involves their future legal strategy. But this is a public article, and I just wanted to put out a video that prosecutors forging indictments seems to be a pattern among these satanic Department of Justice U.S. attorney types. Let's read this. I'll put the link in the information bar. It says, former prosecutor who forged... Come on. Okay, here we go. Former prosecutor who forged indictment wins Jackass of the Month award. It was written by Michael E. McCabe, Jr. on October the 30th, 2015. This month's Jackass of the Month award featured many fine contestants. Each exhibited the qualities of a true jackass: arrogance, intentional disregard of the law, superiority, and narcissism, to name a few. But one attorney stood out head and shoulders above the crowd for his truly loathsome behavior as not only an officer of the court, but as a prosecutor sworn to follow and uphold the law. And so, without further ado, it is with great disgust I announce this month's award for Jackass of the Month goes to Jason Richard Philibom of Cincinnati, Ohio. And justice for all. According to the public records and news reports, in 2010, Philibom was working as a prosecutor in the Butler County, Ohio Prosecutor's Office. In December 2010, another prosecutor in the same office presented evidence in a criminal case against one Tyler Johnson to a Butler County grand jury. The other prosecutor instructed the grand jury to vote on charges of aggravated robbery and felonious assault, but failed to present any evidence on any gun specifications related to the crime. The next week, Philibom reviewed the indictment, noted it did not include any gun specifications, and instructed a legal assistant to add gun specifications to the indictment. The legal assistant told Philibom no gun specifications were included in the indictment because the prosecutor who had actually presented the case to a grand jury had not presented such specifications to the grand jury. The legal assistant felt uncomfortable adding them to the indictment. After she was pressed by Philibom to add non-existent charges to the indictment, the legal assistant complied. The prosecutor who had actually presented the case to the grand jury, however, refused to sign the altered indictment because it was untrue. He had not presented any such evidence to the grand jury. Undaunted by the inconvenience of truth, Philibom signed the indictment knowing it contained a false statement, and further knowing the forged indictment would be filed with the clerk of court. The criminal conviction. On May the 3rd, 2012, Philibom was indicted on 2 counts of forgery, 1 count of dereliction of duty, 2 counts of tampering with the records, 1 count of interference with civil rights, and 1 count of using a sham legal process, all arising out of his conduct in the Johnson case. He pleaded guilty to a single count of dereliction of duty, a second-degree misdemeanor, and was sentenced to 90 days in jail, all suspended on the conditions that he successfully complete 1 year of community control and perform at least 75 hours of community service. Interestingly, Philibom requested that taxpayers pay his legal defense bill as reported under Ohio law. Payment of legal fees only is warranted if the attorney was acting in good faith and he was properly performing his duties as a public official. Philibom's request was denied. The disciplinary action. On March 3rd, 2014, a probable cause panel of Board of Commissioners on Grievances and Discipline certified a 2-count complaint filed against Philibom. The complaint alleged that while employed as an assistant prosecuting attorney in Butler County, Philibom had engaged in prosecutorial misconduct by failing to disclose exculpatory evidence to a criminal defendant and by signing 2 separate criminal indictments containing charges he knew had not been presented to the grand jury. A panel of the board conducted a hearing and issued a report finding that by causing gun specifications that were not presented to the grand jury to be included in the criminal indictment, Philibom had knowingly made false statements of fact to a tribunal, engaged in dishonesty, fraud, deceit, or misrepresentation, and prejudiced the administration of justice, all of which adversely reflected on his fitness to practice law. On October the 27th, 2015, the Supreme Court of Ohio entered an opinion and order suspending Philibom from the practice of law for 1 year. See Disciplinary Counsel versus Philibom, slip-up number 2015, Ohio-4346. The Supreme Court rejected a panel recommendation for a 6-month stay of the 1-year suspension. The Ohio court concluded a 1-year suspension with no stay is the appropriate sanction. A level of professionalism and excellence that will be unparalleled. After being fired from his job as a prosecutor, Philibom hung a shingle touting his experience as an assistant prosecutor for over 10 years. Ironically, as of July 2015, Philibom's website promised his clients with a level of professionalism and excellence that will be unparalleled. Despite his suspension, Philibom's LinkedIn profile continues to tout his current status as a practicing attorney and repeats his promise of unparalleled professionalism. This case was first reported by Legal Profession Blog.